Welcome everyone to today's session where we're looking at some of the recent key decisions of the Court of Justice of the European Union and looking at particularly in the context of the future of a multilateral investment court. We are going to cover quite a lot in our hour today. So the way in which we're going to organise things is we are going to have a short introduction when I will try to do my best to get through the decisions of ACMEA and Opinion 117, which we will be discussing the implications on. And then we'll move into a discussion where we will first look at the implications of these decisions for the intra-EU BIT landscape. Secondly, we'll move to implications for extra-EU BITs. And finally, we'll try to look more clearly into the future and what these decisions mean for the proposals for a multilateral investment court, especially in the context of the Intra-EU Working Group number 3 discussions. If we could put up the slides. I have with me 3 very well qualified panelists to speak on these issues. So if I may take a short moment to introduce them. Johannes Hallberg is a legal advisor at the National Board of Trade for Sweden. In this capacity, he works closely with the Swedish Ministry for Foreign Affairs in all matters concerning international investment treaties. Much of his work concerns investment law and the intersection between investment law and EU law, which is very good for us today. And on a regular basis, he represents Sweden at the OECD, UNCTAD, UNCTAD, as well as the Council Group TPCI. Next, we have Sylvie Tabet, who is a General Counsel at Canada's Trade Law Bureau, where she has been providing trade law advice and negotiating international trade and investment agreements. Particularly relevant for us today, she was the lead counsel for the Government of Canada in the CETA negotiations. And we're really lucky to have her with us because she's currently living in Tokyo, so it's very late for her right now. Finally, we have Colin Brown, who is an international trade and investment lawyer and currently leads the team of lawyers working on investor-state dispute settlement in the trade investment policy of the European Union. He is the lead EU delegate to the Multilateral Working Group number 3 on ISDS reform. So we'll be able to provide us some excellent insights into that. And he also leads the teams providing legal advice to the EU on their FTAs, including of particular relevance to us, CETA. So before we get going, before I start on my quick canter through the recent CJEU decisions, I just want to extend my gratitude of my panelists and ASIL to Curtis Mallet, Prevost, Colt, Mossel, LLP for the generous support for this session. We are very grateful for that. Okay, so if we start with the recent decision of ACMEA, many of you are very familiar with this decision. When it came out in March 2018, it sent shockwaves throughout the international arbitration community because, in short, what it decided was that the ISDS investor-state dispute settlement mechanisms in bilateral investment treaties between member states was incompatible with EU law. Then what I want to do is just highlight very briefly some of the key facets of the decision of the CJEU in this particular case. So the reason in particular that the EU, the court considered that ISDS in the context of intra-EU BITs was incompatible with the EU law was because it called into question the principle of mutual trust and the preliminary ruling procedure, whereby domestic courts of EU member states can refer matters of EU law to the CJEU. And that is a specific legal regime which was established in order to ensure consistency and uniformity in the interpretation of EU law. The difficulty for the CJEU, so far as intra-EU tribunals were concerned, is that they were, in its view, able to be called upon to interpret and apply EU law in order to rule on infringements of the BIT, but they were not obliged nor did not have the mechanism for referring these matters of EU law to the CJEU because they were situated outside the EU judicial framework. Now, since the ground-shaking decision in ACMEA, there has been plenty of activity, which our panelists will come back to discuss. In particular, in January 2019, a declaration was issued by various member states confirming that their view was the effect of the ACMEA decision was that ISDS in Intra-EU BITs was not valid. And a number of states also confirmed their view that this rationale extended to the ISDS in the Energy Charter Treaty, at least insofar as it related to members of the European Union. Some states derogated from that conclusion as far as the EC2 was concerned, including Sweden. Very recently, on the 5th of May 2020, 23 member states signed the agreement for the termination of bilateral investment treaties between the member states of the European Union. The link there is on the slides. And again, that's something we'll come back to cover. Moving on to the position, as far as extra-EU BITs are concerned, those treaties between third parties to the EU and the EU or EU member states. The particularly important decision which came out earlier this year, or ruling from the Court of Justice of the European Union, is opinion 117 of the court. And this was an opinion which was requested by the Kingdom of Belgium, one of the contracting states. And what the Kingdom of Belgium wanted was the court's view as to whether or not the ISDS provisions of CETA in section F of chapter 8 was compatible with primary law. So just a very quick overview of what those were. Firstly, it provided for the creation of a tribunal. Secondly, for the creation of an appellate tribunal immediately, and then subsequently the establishment of a multilateral investment tribunal and appellate mechanism to then replace the tribunal and appellate tribunal mechanisms. So what did the court decide in relation to this, to the CETA ISDS provisions? Well, forward one too much. Firstly, the court decided that the CETA ISDS mechanisms were compatible with the autonomy of the EU legal order. Of particular importance to this decision was the court's finding that the CETA tribunal would have no jurisdiction to interpret and apply rules of EU law, and what they were in fact doing was confined to the provisions of CETA and looking at that in accordance with international law. And there are a couple of aspects of CETA in particular, or provisions within the treaty, which are of particular importance. One is at Article 831(2), which provides that when a tribunal is determining the consistency of a measure of this agreement, it may consider as appropriate the domestic law of a party as a matter of fact. And in doing so, shall follow the prevailing interpretation given to the domestic law by the courts of authorities of that party. And further, that any meaning given to the domestic law by the tribunal shall not be binding upon the courts or the authorities of that party. So in other words, there were a number of provisions within the CETA which sought to ring fence any findings in relation to EU law and to ensure that they did not impact on the development of EU law. Also, the court found that the CETA tribunal and the CETA appellate tribunal were outside the EU judicial system. Secondly, there was no, was the CETA ISDS mechanism compatible with the general principle of equal treatment and the requirement of effectiveness? And here, one of the concerns which had been raised was whether or not a Canadian investor whether there was discrimination or an unequal treatment between a Canadian investor who had access to the CETA tribunal and an investor or national or enterprise of the EU member state who would not have access. And well, without going into the detail of the court's analysis, the court said, well, actually, the two are in not comparable situations because the former is a foreign investor able to rely on CETA. And just finally, in the interests of time, the third pillar of the opinion is to look at whether or not the ISDS mechanisms were compatible with the right of access to an independent tribunal. And this really had two aspects to it. The first was whether or not natural persons or small and medium-sized enterprises would have access on the account of costs. And secondly, whether the constitutional requirements, if you like, of the tribunal and appellant tribunal would meet the requirement of independence. And the court found that they were compatible on both grounds. So far as the first is concerned, there was a stated aim of CETA to ensure the CETA tribunal is accessible to natural persons or small and medium-sized enterprises. Also, the EU would need to, in agreeing to any further proposals as to constitution, would need to ensure compliance, and there was a commitment to doing so. And I've set out on the slide some of the articles which one can look at to see the constitution of the CETA tribunals, but in short, the court was satisfied that they met the requirements of independence by looking at fixed term, the mechanism for appointments, independence and impartiality requirements. So that is the quick canter through those decisions, which I want to get us to get on and discuss. Just a couple of things which are there in the slides, really for your reference. Firstly, that the council, there are a number of council decisions which have put flesh on the bones of the procedural proposals for some of the ISDS mechanisms in CETA, and that's listed on the next slide for your benefit. And then just to draw a distinction between the Energy Charter Treaty, because we will touch on this hopefully. As I said earlier, there is a difference in respect of the current ECT and the approach which may or may not be taken in terms of claims which can be brought under it between for on the Intra-EU basis. But also very recently, so that you're up to date with all developments, there has the EU has recently proposed a text for the modernisation of the ECT in May 2020. So, without further, we want to get on to really discuss what the implications of these decisions are. And I would like to call on Jonas to look at the first area that I said we would cover, which is the implications for intra-EU treaties. And so, Jonas, I want to start by asking you the question, is there any inconsistencies of approach as between the reasoning in ACMEA and Opinion 117?
Thank you, Angeline, for the kind introduction and an excellent presentation of the cases. I'm very honored being invited to take part in this panel and also to speak before such a distinguished audience. I will try to do my best to bring some additional clarity to ACMEA and Opinion 117. Before I start, I should clarify that my views are my own and cannot be attributed to those of the government of Sweden. Regardless, I must confess that some of them may be somewhat influenced by the views of Sweden. To make a complicated matter even more complicated, I'm going to use the old acronym for CJEU, that is ECJ. I will not repeat Angeline's excellent summary. Instead, I will focus on the background of ACMEA and what made the ECJ approve CETA. Let's dig in. The decision, ACMEA and the Opinion 117, both concerns investment law, but they are very different in character. The ECJ is very sensitive when it comes to the principle of mutual trust and the autonomy of the EU legal order. The court showed this already in Opinion 109 related to the International Patent Court, as well as in Opinion 213 on the accession of the EU to the European Convention on Human Rights. In both these opinions, the ECJ stated that the treaty between EU member states that removes the ECJ exclusive jurisdiction over the interpretation of EU law is a treaty in breach of the same law. In the case of the Patent Court, the treaty had to be changed, and when it came to the European Convention on Human Rights and accession for the EU to the Convention, is in my view simply not possible. Returning to ACMEA, In my opinion, the main reason why the ECJ treated commercial and investment arbitration differently was that it is not okay for EU member states to enter into a treaty and that way circumvent EU law and the ECJ. Member states have in Article 344 in the Treaty of the Functioning of the European Union agreed not to do that, and breaching that agreement means breaching the principle of mutual trust. And for the ECJ, the principle of mutual trust is sacred. Then why was CETA okay? Well, first and foremost, if Achmea had everything to do with the principle of mutual trust, CETA had nothing to do with the principle of mutual trust. This since all the EU member states have the same obligations and benefits stemming from CETA. When the ECJ did not have to deal with that problem, the honour judges could instead focus on the other pillar of Achmea, and that is the primacy of EU law and the ECJ's exclusive jurisdiction over the interpretation of the EU law. The question had to be solved in CETA, and as Angeline previously stated, that happened through Article 831. It was made clear that the CETA tribunal has no power to interpret and apply EU law. EU law may only be taken into account as a matter of fact. The CETA tribunal can only interpret and apply the provisions of CETA in accordance with the rules and principles of international law applicable between EU and Canada, including the Vienna Convention. And finally, a CETA tribunal is obliged to abide by the prevailing interpretation given to domestic law by the domestic courts, whilst the domestic courts are not bound by the meaning given to their domestic law by the CETA tribunal. Because of this, the CETA tribunal does not need to have the possibility to make reference for a preliminary ruling to the ECJ. The separation between, on the one hand, applying and interpreting EU law, and on the other hand, treating EU law as a matter of fact, may by some be perceived as an artificial division that under certain conditions cannot be upheld. Then why did ECJ still say that CETA is okay? Well, apart from the fact that the CETA agreement lacks the dimension of mutual trust, I think the reason is the following. The ECJ is a judicial court, but it's also the last instance keeping the EU project together. And this explains why it was important to stop intra-EU arbitration, but it also explains why it was important to keep CETA. If the ECJ had found that extra-EU investment arbitration per se breaches EU law, that would probably also have included all extra-EU member states' bids. And if the ECJ would have crushed all of them, that would have caused turmoil. So in my view, CETA is a compromise between law and reality. Sad to say to this distinguished audience, but everything is not about the law.
Thank you very much, Jonas. And just sticking with the theme that not everything is about the law, if we can just think about what the practical implications of this are now, because of course we now have the termination treaty. What, in your view, are there sort of remaining practical arguments that we can have about Achmea, given where things have moved since that decision was issued, particularly in relation to the intra-EU BITs?
In the termination treaty, it is plainly stated that the parties need to draw the necessary consequences from Achmea. Hence, the termination agreement is a direct consequence of the Achmea decision and has, for my part, nothing to do with Opinion 117. As some of you may know, before the termination agreement, 3 separate political declarations related to the consequences of Achmea were made public. And in all of them were language that the Intra-EU BITs had to be terminated. Hence, the termination of the BITs has never been in dispute by any of the EU member states. And more specifically, when it comes to the termination agreement, that was signed by 22 EU member states, and Sweden was, as stated previously, not one of them. I am personally pleased with that decision, since the declaration, in my opinion, contains language about the relation between EU law and public international law that I find hard to digest. But no matter why Sweden did not sign the termination treaty, I want to make clear that the underlying reason was not that we don't agree with the consequence of Achmea. And it had nothing to do with what I've heard some say, that we want to keep the Stockholm Chamber of Commerce at play. And our analysis is that the dispute articles in the Swedish Intra-EU treaties, they are all similar to the one in the underlying treaty to Achmea. And for this very reason, Sweden has bilaterally already terminated about half of its intra-EU treaties and are on its way to terminate the rest. For the EU member states that have signed the termination treaty, I imagine that they perceive this now as a done deal. As soon as the termination treaty takes effect, the intra-EU BITs do not exist anymore, and neither do the sunset clauses that they contain. So now it's up to you, all of you lawyers, to fight over this on behalf of your respective clients. I also imagine that some of you have personal views when it comes to the termination treaty's effect on the sunset clauses, and I'm very much looking forward to the arguments there.
Yes, I think there will be lots of arguments to be had about this in due course. Just a quick word from you before perhaps I can invite the other panelists to see if they have any comments on Intra-EU BITs before we move along. But obviously in the termination treaty, the ECT is carved out from that. And I just wondered if you can offer any thoughts as to where this leaves the ECT. Have you got any comments or predictions to make?
Well, in the termination treaty, it is explicitly stated that it does not cover the Energy Charter Treaty. What also is stated is that the member states of the European Union will deal with this matter at a later stage. What this actually means, of course, is open for debate and interpretation.
Is that anything more than a reference to the modernization treaty?
Well, my impression is that deal with at a later stage means that the EU Commission wants its member states to agree that the Energy Charter Treaty is not applicable between them. And the end result would then probably be an ECT termination agreement like the one concerning the intra-EU BITs. However, to agree on this will not be easy, and not to mention how such an agreement would relate to the Article 16 in the Energy Charter. As many of you know, of course, some EU member states have strong views that the Energy Charter cannot be applied intra-EU. And other countries are of the opinion that this is a matter that's decided by the ECJ. And considering Achmea and Opinion 117, in my opinion, it's far from clear that the Energy Charter Treaty breaches EU law. And we must not, of course, forget that the Energy Charter today is a part of the EU acquis. And it would, in my view, be wrong if the political level, without proper legal support, decides that this protection cannot be used.
That's very, very interesting. I wonder, sorry, not to cut you off, but in the interest of time, I think it would be interesting to bring Colin in to just comment on this particular point. Colin, do you want to make some observations on what Jonas has said?
Yeah, just wanted to come in briefly on the Energy Charter Treaty and the question of the intra-EU application of the Energy Charter Treaty. So the view of the Commission is indeed that the Energy Charter Treaty does not apply between the different EU member states. It wasn't possible to reach an agreement on that, as has just been noted, in the context of the declarations and in the context of the termination treaty. But I think from the Commission's perspective, this is in fact the correct reading of the Energy Charter Treaty as it stands today. So to pick up a little bit on where you were hinting at, Angeline, it's not, in our view, something that is appropriate for the negotiations on the modernization of the Energy Charter Treaty, which are to, as its name suggests, to modernize and to improve the Energy Charter Treaty, but it rather flows from the structure of the Energy Charter Treaty and the structure of the European Union there. We expect that to be, has been litigated, and we expect that litigation to continue and eventually probably find its way to the Court of Justice. Thank you.
Very good. Thank you. Jonas, do you want to have a final comment? I don't know if you want to wrap up, because I think we'll then move to the extra-EU position.
Oh, I'm fine.
Very, very good. Well, thank you both for your input on that. I mean, despite the fact that there's been some quite dramatic developments, obviously, in this area in the last couple of years, it's still something which I think we haven't heard the end of completely yet. But if we move on to the implications for Opinion 117 for the extra-EU treaties, Sylvia, I wanted to bring you into the discussion on this. Just thinking about the rationale of the court in Opinion 117, what risk is there of incompatibility between the ISDS procedures envisaged in CETA and the EU, in terms of both the institutional limitations of the EU and then also potentially case law? I wonder if, from the perspective of the Canadian perspective, you could give us your thoughts on that. Does Opinion 117, is that a source of great comfort, do you think?
Thank you, Angeline, and thank you to ASIL for having extended the invitation to participate in this panel today. And like Jonas, I will make the standard disclosure that my comments will, of course, be my own and do not necessarily represent the views of the Government of Canada. And maybe to answer your question, the best place to start is to framing the ECJ decision in 117 in a bit of a historical perspective. And to start by saying that I think there were two main factors that influenced the development of the investment protection chapter in CETA. The first is Canada's practice, both as home state of investors using ISDS and respondent in many NAFTA cases. And the second one was the backlash that the EU received against TTIP, which forced a bit of a profound reflection and rethinking by the EU and member states with respect to their approach to investment protection. And so the issue of compatibility with EU law arose in that context. It didn't suddenly arise after the conclusion of the CETA agreement. If you look at what happened during the final phases of the CETA negotiations in late 2016, there were a number of adjustments that were made to the investment text to address concerns that were being expressed about compatibility with EU law. And many of those elements are also found in the October 2016 joint interpretive instrument, which accompanied the signature of the agreement. So in effect, many of the questions that Belgium raised in the reference on CETA compatibility had already been the object of discussion, and the opinion wasn't much of a surprise. But maybe I can just offer in my presentation today some brief thoughts on some of the aspects of the opinion, not from the perspective of EU law, because I'm not an expert in EU law, but with respect to potential implications for current and future EU treaty partners. And I will start with, my first observation will be with respect to the court's finding on the CETA Investment Tribunal. And Angeline, you set out the stage earlier by explaining some of those findings and how the CETA departed from the previous practice, both of member states and Canada, to allow investors to have recourse to ad hoc arbitration, and instead to provide for recourse to a permanent investment tribunal structure with an appellate mechanism. So in finding that dispute settlement mechanism compatible with EU law and with the right of access to an independent tribunal, the court looked at those provisions at the joint interpretive instrument and recognized the parties' strong emphasis on independence and impartiality of tribunal members, including with respect to terms of appointment and remuneration, also ethical rules to avoid conflict of interest, and the provisions dealing with SMEs. Now, as has already been, as was anticipated in the agreement, the EU and member states and Canada have already begun working on the implementation of those provisions. What has been done to date is very much in keeping with the importance placed by the courts on some of these elements. So the Committee on Investment, the CETA Committee on Investment Services, has already developed rules setting out the functioning of the Appellate Tribunal, Code of Conduct for the members of the tribunal, rules for mediation, and rules for binding interpretations to be adopted by the CETA Joint Committee. And so these rules will be adopted by the CETA Joint Committee after each party has completed its domestic approval process. Now, while some people have, the court really only dealt with the question of whether the CETA Investment Tribunal is compatible with EU law, but some people have implied that this was the court setting conditions for investment dispute settlement outside of the EU judicial system going forward. I think the Opinion 117 does not expressly rule that ad hoc arbitration in non-intra-EU agreement is incompatible with EU law. And so it's not clear that the court concluded that the permanent court structure is the only one consistent with EU law. And in fact, it looks like the EU is not pursuing dispute settlement reform in its modernization proposal in the Energy Charter Treaty, for example, which suggests that ad hoc arbitration with non-EU member states or between non-EU member states is not necessarily incompatible with EU law. Now, the dynamic in the context of ongoing and future negotiation is a bit different. So even if the EU is prepared to accept ad hoc arbitration, which they don't appear to be, there is a bit of a risk of a challenge that remains in that respect. So whether or not the court mandates a CETA-style investment dispute settlement system, at the very least, it provides comfort to treaty partners negotiating with the EU that this type of mechanism is compatible with EU law. And so the CETA-style agreement on investment, which is very similar to what is in Singapore and Vietnam, is likely to be the model for the EU agreements going forward. Indeed, because of the issue of competency, the EU is now negotiating investment agreements separately from its trade agreements. The result has been that, for example, the trade agreement with Japan was concluded without an investment protection agreement, and the negotiations with New Zealand and Australia do not include investment protection. And some of the potential future negotiating partners of the EU who are not so keen on a CETA-style investment court may be reluctant going down the line to enter in these kinds of agreements. You've already made some observations on the issue of the applicable law and the autonomy of the EU legal order. I think I somewhat share some of Jonas's comments that I'm not sure that this the CETA applicable law provision was much more explicit, that EU law, that the investment tribunals will not interpret EU law. However, I'm not sure that that was the decisive factor. It may more have to do with the principle of mutual trust. I don't think the CETA applicable law provision really changes the status quo in a sense. It is more explicit and clearer, but usually domestic law is looked at as a fact by international tribunals. So this is not really a revolutionary in a sense. And I think we can also expect that EU law will be in some ways interpreted by investment tribunals in that, for example, in considering the scope of what is the investment, what are the rights that were accorded under EU law. And so that will require some consideration of EU law. Nevertheless, the court found some, certainly in Opinion 117, seemed to have found some comfort in the language in the applicable law provision. If you can give me a few more minutes, I'll just briefly comment on the court's consideration of the substantive standards in CETA, because I think this is another really important aspect of the decision, and it's the conclusion that it was compatible with the autonomy of the EU legal order. And the court really very carefully looked at the interpretation of the FET and the FET provision and the indirect expropriation clarifications, the care that the parties took to preserve the right to regulate. For example, in Article 8.9, investment and regulatory measure, the court noted that the parties have taken care to ensure, and I'm quoting from the decision, that the parties have taken care to ensure that those tribunals have no jurisdiction to call into question the choices democratically made within a party relating to the level of protection of public order or public safety, etc. And on this basis, it concluded that the investment chapter does not affect the autonomy of the EU legal order. So a very direct implication of that is that we're going to see the substantial standards in CETA that are also in Vietnam and Singapore are going to be replicated in future EU treaties. And in fact, we can see that the language in the EU ECT modernization proposal is also very similar to what you find in the CETA agreement. And it does raise an interesting question as to what would happen in a case where an investment tribunal came to a different interpretation or an interpretation that the court does not necessarily view as consistent with its view of these standards. And would this be a ground, for example, to refuse to enforce the decision because it could be seen as incompatible with EU law? Now, if the EU and member states' approach to the recognition of enforcement of the Maquila Award or the various awards against Spain are any indication of how this discrepancy would be approached, it would certainly raise some concerns, but maybe I'll leave it at that and open the door for
well, Sylvie, Maya, thank you for that really excellent. Please don't, we wouldn't stop you if we weren't constrained by time. It was a really excellent summary and very thoughtful analysis. We're grateful for it. I thought before, I do want to come back to Colin to raise many of the points which Sylvie's made and get his perspective. But before I do that, Jonas, would you like to comment first on some of the things you've just heard?
Yes, I can just rapidly say that I absolutely agree with Sylvie when it comes to the principle of mutual trust and the importance of that of CETA. And that's what I tried to say when I said that CETA had nothing to do with the principle of mutual trust, in the sense that there is nothing in the agreement that has any effect on the mutual trust.
Thanks, Jonas. Very good. Well, let's see how much measure of agreement, I'm sure there'll be lots of measure of agreement, but I'm interested to get your views, Colin, and in particular whether you think the CETA model, which has been endorsed by the CJEU, is the sort of blueprint going forwards, and how, moving into the third part of our discussion, what the implications are for that for either future treaties with the EU or indeed, and then beyond into a multilateral investment court, which is under discussion by the Intra-EU Working Group number 3 at the moment.
Yeah, so thank you very much, Angeline. Thank you for your introduction, and let me also thank the organisers for having invited me to take part. I think we need to see, I think, from the European Union's perspective, there are different elements that are pushing forward this policy. So there's the policy impetus of the European Union and its member states taking a position that there should be a reform of investor state dispute settlement, and that reform should move towards permanent bodies settling disputes. And I'm happy, I won't elaborate in detail why we believe that, but I'm happy to do that. And then there are legal restraints or constraints that come from EU law, and as interpreted and reiterated by the Court of Justice, not only in Opinion 117, which of course is on investment, but it's building on a long line of previous opinions on the relationship between international tribunals and EU law. So a large part of the reason that the EU will seek to have mechanisms like we have in CETA in the agreements that we have negotiated and we will negotiate in the future are policy reasons. They're driven by policy reasons. And the court, and to pick up a little bit what Sylvie was saying, the court has only ruled, of course, on the CETA mechanisms. It hasn't been asked to rule on a circumstance of investor-state dispute settlement, if you want, traditional investor-state dispute settlement in extra EU treaties and treaties with third countries. So there's a to an extent there's a question mark about whether such a mechanism would actually be consistent with EU law. And I think in that regard, it's important to keep in mind something that you had in the slide, Angeline, earlier on, which is that the court applied, it wasn't the first time, but the court applied the EU Charter on Fundamental Rights to the EU's external action in analysing CETA. And amongst the Charter's provisions is a provision saying that everybody's entitled to a remedy before an independent and impartial court. And so part of what the court did was analyse that and conclude, as you said, that the CETA system is compatible with that. But a question I think that would arise, were there to be a case of an EU agreement that included ad hoc ISDS, would be whether such a mechanism would be consistent with the Charter on those particular grounds. So there clearly it is an open question there. But the EU's policy approach, as I said, is very much to pursue the development of permanent mechanism. In the Energy Charter Treaty modernization process, we have not specifically proposed a permanent body within the context of the Energy Charter Treaty. But what we've proposed is that the Multilateral Investment Court that we would like to see as an outcome from the Intra-EU Working Group 3 would apply to the Energy Charter Treaty. So that's a particular choice that's been taken, but there's a very clear preference to ensure that we continue with the establishment of permanent bodies to regulate investment disputes. Now, does and there's a question that came in on this as well, does the court's opinion, does Opinion 117 shape the way the EU will pursue multilateral investment court in the context of Intra-EU? I think my simple answer to that question is that it does shape the direction, but the direction, or rather the European Union was already on that path previously. So it doesn't require us to change direction, but it confirms that the direction that we were going in needs to be maintained. And so one element of that is the applicable law elements, which we have been touching upon. And something that the European Union will have to do is to ensure that any eventual multilateral investment court does not rule on EU law in a way which is binding upon the EU institutions. That we think would be done on the basis of the language that was examined in Opinion 117, which appears in CETA, but which also appears in Singapore, Vietnam, and Mexico agreements, and which we've put on the table also in the ECT modernization process as well. The question also arises for the member states' bilateral investment treaties, because one of the big objectives of the European Union in the Multilateral Investment Court discussions is to ensure that it applies also to the member states' bilateral investment treaties. These don't, and here I think I would agree with Sylvie, we have elaborated on this idea of applicable law in CETA, but we haven't changed fundamentally what was there, this understanding that the tribunals would rule on matters of international law and would look at domestic law as a matter of fact. So because we've elaborated on it, it may well be, and I think we're fairly comfortable with the idea that it's not necessary to always have that elaboration, as long as it is clear that tribunals can only, and the Multilateral Investment Court could only rule on matters of international law and not on matters of EU law in a way that would be binding for the European institutions and particularly the Court of Justice. The other two things I briefly mentioned that I think are also important in terms of the direction that is given by Opinion 117. One is what the court has said about ensuring the protection or the level of protection decided by democratic means can be maintained and is not undermined. And again, Sylvie mentioned that. You have, of course, in CETA, language which clarifies the main substantive standards and elaborates on them. And that is language, as again, as Sylvie noticed, that we put forward in other negotiations, we put forward in the Energy and Charter Treaty as well. But our belief is that is really, this language is really clarification. And one of the fundamental ideas behind the Multilateral Investment Court is to bring about stability in interpretation, to bring about predictability, so that the existing ad hoc system, where it's difficult to tell how a particular legal matter will be resolved, moves towards a system where you have stability, where you have clarification, and when you can be comfortable that the clarification will carry through into future rulings. So I think we would be hopeful that these substantive questions would be resolved not necessarily through writing out the elaborations that we've done in CETA and other agreements, but through the case law of a multilateral investment tribunal, multilateral investment court, as it took out, as it developed over time. And then the second point that I would also make is that, as I mentioned earlier, the court examined the CETA tribunal and system also on the basis of the Charter of Fundamental Rights. And obviously that would also apply, that analysis would also apply to a multilateral investment court. What does that mean? It means that the result must ensure the independence and impartiality of the adjudicators that are chosen to sit on that court. So they must be independent from government, because they'll be reviewing government action. They must be independent from other actors. And they must be protected in such a way that that independence can be ensured throughout their tenure. And let me finish by just briefly, and I have to say, respond briefly on this, because Sylvie mentioned the EU's reaction to Mikula and to some of the Spanish renewable energy cases. I think it's important to highlight again, these are intra-EU cases. And the approach of the European Commission is that the underlying treaties are invalid, therefore there's no basis for these rulings in the first place. The EU is an animal of international law. We're subject to a number of international tribunals. And it is a day-to-day matter for us to have slightly different interpretations of issues in, for example, in the WTO panels or appellate body, and in Luxembourg and the Tribunal of the Law of the Sea. That is something that the judges in Luxembourg live with, understand. And so in my view, it's quite clear that those types of inconsistencies that will naturally arise, as long as they don't lead to a systemic interference, which will be avoided if we separate the questions of applicable law. These little inconsistencies and issues which will arise will not arise to such an extent that they could lead to refusal to enforcement in the EU for extra EU treaties. So I'll stop there. Thank you very much.
Thank you very much, Colin. Perhaps we've got 5 minutes left before the end of our session, so I wonder if I can just take some of the questions which we have received and put them to our panelists. And of course, you may also use that opportunity to comment on anything else that you've heard. There is a question probably to you, Colin, I think, about thinking about the approach which the EU has taken. Are there any fears that by creating this court, it will crystallise the EU's dispute settlement system and create inflexibility and limit future reforms? So perhaps if you can think about that. And another one that perhaps I will flag, which is to Sylvie and or Jonas, which is, are there concerns about respect for human rights and arbitration decisions? And I suppose in particular, maybe one of the things that was particularly important in the opinion 117 was the right to regulate. And I don't know whether you want to comment about that concern and how that drives negotiations of some of these treaties. And then if we have more time, we'll come back and ask some more questions. So Colin, do you want to start?
Yes. Yes. So let me say that this question on potentially or the risk of crystallization and then a question of lack of flexibility. This is something that I think that we're conscious of. I think the international community, this society in particular, has had the advantage of looking at and learning from the functioning of international courts and tribunals, in particular over the last 25 years. Something that I think is fascinating in the Intra-EU process is the input of academics who are also have been studying this and are bringing their analysis into the discussions. So something that we are conscious of in looking, and it's still too early to see this clearly, but in looking at what the outcome in Working Group 3 could be is that we need to have something that has sufficient flexibility to be able to adapt to challenges over time and to be able to adjust. And it's quite clear to us that having something which is too rigid let me clarify, too rigid on particular issues may pose problems further down the line. So we need flexibility built into the mechanism. And if you look at the European Union and the member states paper to Intra-EU from January 2019, you will see in there a discussion about a certain amount of flexibility that has to be built into this. Can I answer, Angeline, also the question on rule of law? Do you mind if I pick up that?
No,
sorry,
please go for it. Yes, you may want to just explain what it is first.
Right. So there's been a question posed of does the approach on intra-EU BITs and the creation of a permanent court externally, does that undermine the rule of law? Now, I think I can answer that very briefly. I can answer it very longly, but I'll give you the brief version. The brief version is the European Union consistently seeks to uphold the rule of law. Intra-EU, it is a question of which tribunals are the appropriate tribunals, which courts are the appropriate courts to deliver that. And from the perspective of the European Union, it is the national courts on the basis, if necessary, of EU law with the backup of the Court of Justice that will deliver rule of law within the European Union. And externally, we think that a permanent body can perfectly well deliver rule of law. It's a question of design of that mechanism. I mentioned earlier on the question of independence and impartiality is extremely important. But we all live with permanent courts. We have permanent courts in our national systems. And these function well and they deliver the rule of law. And they function well and deliver rule of law because of design. So the question is, how can we and the colleagues in Intra-EU Working Group 3 develop a process which ensures as a matter of design that you have independence and impartiality and that you have respect for rule of law. I'll stop there and let others come in.
Thank you very much, Colin. I don't know whether before we might go to Sylvie to address the question I raised earlier, but perhaps we should just bring Jonas in to see if he wants to comment on anything which Colin has said. And a question in particular has been raised about when negotiating an international court, how do you think about the relationship of the national courts more generally, in particular referencing the recent German Constitutional Court case. Jonas, do you have any observations to be made in relation to this, and in particular the intra-EU aspect, before we go back to Sylvie?
Well, I just would like to make one brief comment, and that is something that we've heard among other places at the Amsterdam. Is sort of the misconception that the European Commission, Colin, sort of is the train and everybody else is just following along. The EU point of view is something that has been discussed and negotiated internally, and Sweden is very much pro this discussion, and almost all other countries as well. I think there might be some exception that, but I mean, when it comes to actually the creation of a permanent body, we are all behind. This is something that must not be forgotten.
Yes, thank you very much. Well, perhaps we can move to Sylvie now to pick up on the question which I posed earlier about the right to regulate and the concern which was raised about decisions of tribunals and human rights.
Right. I think the first comment I'll make is that, of course, substantive reform is not being discussed right now at UNCITRAL. But the issue of human rights and how that comes up is very much on everybody's mind, and the importance of the right to regulate and finding the right balance on the substantive obligation. That's reflected, in corridor discussions and in discussions about various approaches to reforming investment treaties in people's bilateral negotiations. It has also come up in the context of discussions on counterclaims at UNCITRAL Working Group 3. And those discussions have just started, but that may be another place where further discussion on human rights and potential counterclaims is developed. In the interest of time, I'll stop here, but there is a lot to say. I think I want to emphasize that finding the right balance on right to regulate is something that we have, we're now developing and coming to much clearer language than we had in some of our earlier treaty. And it's hopefully that will signal to tribunals the correct direction in the interpretation.
Thanks so much, Sylvie. That's a really useful insight, I think. Colin, can we come back to you to address the question about the relationship between an international court and the national courts, if you wouldn't mind?
Yes, thank you. So there's a question on would there be a problem for national courts referring, of course, to the German Constitutional Court's recent decision on the ECB's bond buying program. Clearly, I think all of these courts will potentially, I don't know if necessarily would be an issue, but all national Supreme Courts are going to want to, or may want to make sure, or maybe ask the question, whether any outcome in UNCITRAL Working Group 3 is consistent with domestic constitutions. I think the answer to that generally has to be yes, that international judicial systems are consistent with domestic constitutions. Otherwise, we wouldn't be able to enter into them in the way that countries have done so. But that will be a factor that will be there that people will have to take account of. I'm not aware of any other case law anywhere comparable to what we see now in Opinion 117 anywhere else in the world that goes into this question in as much detail. But if it is there, it may be something that we have to take care of. Thank you.
Thank you, Colin. Thank you very much. Well, I think we've very sadly run out of time for our session, but I want to thank my excellent panelists for doing such a good job of covering such a broad number of topics in a short space of time. So thank you very much for your time. And thank you also to ACEL for putting this programme together, covering this really important set of issues. Thank you very much.
Thank you.
Thank you.